G'day, it's fugitive Australian journalist Shane Dowling from the website and YouTube channel Kangaroo Court of Australia. Now, I've just published an article whereby I analyse a court case where the lawyers for Israel were trying to intimidate Australian media via contempt proceedings. Now, I'll read that article out now. The article is titled Lawyers for Israel, Big Loss in Court Against Nine Entertainment. I published it on Sunday the 20th of July 2025. And it starts off, 9 female lawyers from the Lawyers for Israel WhatsApp group have lost their application for the judge to order the registrar of the Federal Court of Australia to institute contempt proceedings against 2 companies and 6 employees from Nine Entertainment. Nine Entertainment is a large media organisation in Australia. The application was frivolous and vexatious, and what they were trying to do was weaponise contempt laws to silence Nine Entertainment and then go after other media and social media users, which could have included me in this website, but more on that in a minute. Background. On the 20th of December 2023, journalist Antoinette Lattouf was sacked by the ABC after the Lawyers for Israel WhatsApp group, with 156 members, ran an email campaign with the support of News Corp to pressure the ABC management to sack Lattouf. In January 2024, the Sydney Morning Herald published leaked messages from the Lawyers for Israel WhatsApp messaging group, which exposed their organised email campaign to the ABC management, including then ABC chair Ida Buttrose, to have Antoinette Lattouf sacked. Antoinette Lattouf instituted unlawful termination proceedings, with the hearing held in February 2025. On the 25th of June 2025, the court found that Antoinette Lattouf's allegations had been proven and granted consequential relief. At the start of the hearing, 9 female lawyers from the Lawyers for Israel WhatsApp group applied for and were granted suppression orders because their email complaints to the ABC, with their names and contact details, were part of the evidence filed in the case, and their lawyers said they'd face harassment if their details were not suppressed. The proposed suppression order was not opposed by Antoinette Lattouf or the ABC. The 9 female lawyers claimed the 2 companies and 6 employees from Nine Entertainment breached the court orders, and they filed an application seeking to have the judge order the registrar of the court to institute contempt proceedings. In the judgment on Friday, the 18th of July 2025, Justice Rangier said at paragraph 4, on the 3rd of February 2025, the first day of the hearing, I made suppression and non-publication orders in the following terms. Pursuant to Section 37AF of the Federal Court of Australia Act, and on the ground that it is necessary to protect the safety of persons for a period of 10 years, the names, identities, contact details and addresses of persons who made complaints to the respondent about its employment or engagement of the applicant, which is Antoinette Lattouf, in December 2023, are not to be published or otherwise disclosed, may only be accessed from the court file by the court staff or a party to these proceedings and their legal representatives. In paragraph 5, he says, in my reasons, I noted that the hearing was being live streamed and that online file had been established to which affidavits read in open court, exhibits and other documents would be uploaded and be accessible to members of the public. This had the consequence of bypassing the process under Section 2.324 of the rules, which requires a court's leave to be sought to access affidavits that have been filed. I was satisfied that the order was necessary to protect the safety of the intervening parties because of substantial risk they would face at least vilification and harassment if their identities and contact details were made available to the public. Paragraph 6. The interlocutory application is concerned with the following news articles. An article first published in The Age and the Sydney Morning Herald on the 16th of January 2024. The second article first published in The Age and the Sydney Morning Herald on the 16th of January 2024. An article first published by the Pedestrian TV on the 16th of January 2024. And an article first published in the Sydney Morning Herald on the 17th of January 2024. Paragraph 7 of the judgment. It may be observed that each of the articles was first published about a year before the order was made on the 3rd of February 2025. The articles remained available online even after the order was made. The intervening parties allege that the order required the publishers to take down the articles and that the alleged contemptors contravened the order by failing to do so. Paragraph 8. Although the intervening parties submit that another article published in the Sydney Morning Herald on the 3rd of February 2025 also breached the order by referring to the January 2024 articles. They do not allege any contempt in respect to that publication because the article was amended to remove the reference on the same day. Paragraph 9 of the judgment. The alleged contemptors are The Age Company, publisher of The Age; Fairfax Media Publications, publisher of the Sydney Morning Herald; Bevan Shields, editor of the Sydney Morning Herald; Patrick Elliott, editor of The Age; Lorena Ellick, in-house lawyer; Sam White, in-house lawyer; Callum Jaspin, journalist; and Michael Batchelard, another journalist. The first two contemptors are companies owned by Nine Entertainment, and the other six are ultimately employees of the parent company Nine Entertainment. Paragraph 26 of the judgment says, it is apparent that the court would not order the registrar to start a proceeding for contempt that has no reasonable prospect of succeeding. It can be accepted as a general proposition that the more obvious or blatant the alleged contempt appears to be, the more likely that it is the registrar would be ordered to commence a proceeding for contempt. This proposition takes into account both the undesirability of the registrar expending public funds in prosecuting a case of doubtful merit, and the possibility of costs being ordered against the registrar. Paragraph 29 says, in Regina versus Herald and Weekly Times, Justice Dixon held at 81 that to establish a contempt of court on the basis of a publication or of a report in breach of a suppression order, the applicant must prove beyond a reasonable doubt that A, the respondent published the article or caused it to be published; B, the publication of the article frustrated the effect of the suppression order because it contained material that was contrary to or infringed the terms of the order. C, when the article was published, the alleged contemptor's knowledge of the terms and effect of the order was such that a reasonable person with the knowledge would have understood that the continued publication of the article would have the tendency to frustrate the efficacy of the order. Paragraph 32 of the judgment says, the articles published by The Age and the Sydney Morning Herald on the 16th of January 2025 disclose the name of a WhatsApp group said to have organised a letter-writing campaign demanding that Ms Lattouf be sacked. The articles named 4 persons as being associated with the campaign. 2 of them are intervening parties. The articles directly name one of those 2 persons as having made a complaint to the ABC in December 2023 about Lattouf's employment. It is reasonably arguable that by indicating other named persons encouraged members of the group to write to the ABC. The article suggested that the named persons had already written to the ABC. The article of the 17th of January 2024 contained a link to the Sydney Morning Herald articles published on the 16th of January 2024. Paragraph 45 says, I am satisfied that all of the alleged contemptors have established a reasonably arguable basis for defending the allegations of contempt. They have demonstrated a reasonably arguable case that the order only protected the 9 intervening parties and only protected information derived from material on the court file or from the proceedings. Further, they have a reasonably arguable case that in the absence of being notified of the identities of the relevant 9 intervening parties, they could not know what information they were prohibited from disclosing. Paragraph 60 of the judgment says, in these circumstances, the appropriate order is that the intervening parties pay half the alleged contemptor's costs as between party and party. The judge also said at paragraph 42, I am satisfied that the intervening parties have established a reasonably arguable case of contempt against the Age Company, Fairfax Media Publications, Mr Shields, Mr Elliott, Mr Blanchard and Mr Jaspin. And I go on to say in the article, that is not true. The arguable case of intervening parties, 9 female lawyers, was frivolous and vexatious at best. But the judge probably thought if he said that, it would pour fuel on the fire. So I was diplomatic when he said the intervening parties have established a reasonably arguable case. The judge never made a finding about whether the suppression orders had been breached, and if he did, he'd have to find they weren't breached because no court orders were issued to take down previous articles naming the applicants, and no one knew who the applicants were. The dodgy strategy of the 9 female lawyers from the Lawyers for Israel group. On the 3rd of February 2025, the same day the suppression orders were issued, the Sydney Morning Herald published an article which referenced previous Sydney Morning Herald articles from 12 months earlier, which the judge said named 2 of the 9 women applicants. Rebecca Giles, the lawyer for the 9 women, wrote to the journalist Callum Jaspin complaining the article published on the 3rd of February 2025 was in breach of the court orders, as she claimed the court orders covered all articles that named anyone who had made a complaint to the ABC about Antoinette Lattouf. That was a huge lie by Rebecca Giles, as nowhere in the court orders, see paragraph 4 above, does it say that. But Callum Jaspan edited the 3rd of February 2025 article to take out the references to the earlier articles naming the women. Why Callum Jaspan edited his 3rd of February article, I don't know, but it seems he fell for Rebecca Giles' lie. After being given an inch, Rebecca Giles decided to take a mile and started an email campaign to Nine's internal lawyers to have the articles from January 2024 taken down or amended to delete the names of the 9 female lawyers for Israel, or amended to delete the names of the 9 female lawyers from the Lawyers for Israel group. The only way the court orders could be breached is if someone had access to the court file and also had a full copy of the court orders with the names of the 9 suppressed women. Nine Entertainment and their staff had neither. Nine Entertainment and their internal lawyers ignored Rebecca Giles' email campaign for weeks, but after a while decided to edit the articles, which complied with Rebecca Giles' demands, even though Nine had no legal obligation to do so. Why the contempt proceedings, given Nine Entertainment complied with the demands of 9 female lawyers from the Lawyers for Israel WhatsApp group. Given Nine Entertainment complied with the demands of the 9 female lawyers months ago, even though they are not in breach of the court orders, why did the 9 female lawyers continue with their contempt application against Nine Entertainment's companies and staff? I believe that if the 9 female lawyers had won on Friday, the 18th of July 2025, and the judge ordered the Registrar of the Federal Court of Australia to institute contempt proceedings against 2 companies and 6 employees from Nine Entertainment, then Rebecca Giles would have started an email campaign to other media and social media users demanding they take down the names of the 9 female lawyers or face contempt proceedings like Nine Entertainment. The bottom line is that 9 female lawyers were trying to weaponise contempt proceedings to intimidate the media. They would have likely been thinking there was no need to wait for a judgment, as they knew they would lose against Nine Entertainment in the contempt matter, as just having a contempt matter afoot would be enough to intimidate other media and social media users. Criminal offences by the Lawyers for Israel group. It is arguable that the 9 female lawyers from the Lawyers for Israel group and others from the Lawyers for Israel group are guilty of numerous criminal offences for their pursuit and harassment of Antoinette Lattouf, as well as breaching defamation law for the public lies they have told about Lattouf online. Such crimes would include, but are not limited to, using a carriage service to menace, harass or cause offence, which is a criminal offence under Section 474.17 of the Criminal Code Act 1995. I also covered the fact they are in breach of Australia's foreign influence laws in the below video I published on the 14th of July 2025, and I'll put a link to that video below this video on YouTube as well. Closing arguments. I also have articles and social media posts from 12 months ago that name some of the lawyers from Israel WhatsApp group that complained to the ABC, which I quoted from the Sydney Morning Herald articles. But I've not taken the articles and social media posts down because I know I'm not in breach of the court orders. When lawyers believe suppression orders and or non-publication orders have been breached or are concerned they might be breached, they'll send a full copy of the orders and demand you comply with orders. That happened to me in 2023 when there were suppression orders stopping people naming former My Kitchen Rules star Claudine Yamakimu, who was facing criminal charges. Rebecca Giles, the lawyer for the 9 female lawyers, has failed to send the full copy of the court orders to anyone that I know of, including Nine Entertainment. Why? Because Rebecca Giles and her clients, the 9 female lawyers, know that Nine Entertainment and their staff were not in breach of the court orders, and that is more evidence of their big lie. The 9 female lawyers from the Lawyers for Israel group would be well advised to leave it there and move on, but they could appeal Justice Rangier's judgment or could institute contempt proceedings themselves, which would be very costly when they lose, and that is why they wanted the court to run and pay for the contempt case. The bottom line is that the 9 female lawyers from the Lawyers for Israel WhatsApp group were just trying it on. They didn't have to have a big win. All they were trying to do was get the court to institute contempt proceedings. That would have been enough, even if it ultimately lost, because once the court instituted the contempt proceedings, at that point, before it had even gone to trial, they could start writing to other media and saying, look, this is going to happen to you too. You're going to have contempt charges against you. So even if they ultimately lost, which I have no doubt they would have, just having that afoot was enough to empower them to weaponise the court proceedings. It was 6 months down the track when they ultimately would have lost the contempt matter. Well, people would have forgot about it. The media would have already wiped the names of those 9 female lawyers off the internet and their websites. Anyhow, make sure you visit my website, Kangaroo Court of Australia. There's a lot of links there with a lot more information, links to the judgments, And please do your bit and help shine a light on corruption and share this video on social media. And please hit the like and subscribe button and notification button. That way you get notified every time I publish a new video. In Kangaroo Court of Australia's independent media, I publish a website and a YouTube channel, and I'm 100% crowdfunded from viewers like yourself. So please make a donation on either PayPal or Patreon. The links for PayPal and Patreon are below this video on YouTube and also on my website. Or you can go to my website and click on the donations page, and there's other donation options there. Other than that, thank you for your time and have a good day.